Hey, I want to thank everybody for joining us today. My name is Christy Stewart. I am the Physician Relations Coordinator for the Medical Society of Delaware. I want to welcome you all for joining us today. We have a great presentation on proper handling of confidential information, practical tips for HIPAA, subpoenas, ICE, and otherwise. This presentation is a joint presentation presented by Bruce Armon and Jessica Jones from Saul Ewing LLP. Um, our first presenter will be Bruce Armon. He is the chair of Saul Ewing Healthcare Practice. He counsels clients on how federal and state healthcare laws affect healthcare practices and businesses. His understanding of corporate healthcare systems from a combination of his work with physicians, physician groups, trade associates, hospitals, academic medical centers, ancillary providers, device manufacturers, veterinarians, healthcare entrepreneurs, and insurers, as well as his previous experience in Pennsylvania legislature and the health insurance industry. Bruce also brings insight on the leadership challenges his clients face from a day-to-day and long-range planning perspective. Bruce speaks often to physicians and healthcare audiences and regularly writes and is quoted about healthcare issues in external publications. Our second presenter is Jessica Jones. She is a legislator who focuses primarily on disputes affecting colleges and universities. Her experience includes representing institutions in matters ranging from tenure disputes and discrimination claims to issues involving um, Title, oh God, Title 5 and I'm unsure on the titles here, including cases involving sexual assault and allegations. Beyond her higher education work, she assists with litigation involving clients in the healthcare industry, including medical practices and nursing homes. She has also advised on healthcare policy matters affecting institutions of higher education, such as mental health and vaccines. Her understanding of these issues is informed by her master's degree in bioethics from the University of Pennsylvania um, School of Medicine and her involvement in various healthcare focus groups and associations. Welcome, Bruce and Jessica. We're very excited for your presentations. If anybody has any questions, please be encouraged to insert them in the chat box. Those questions will be addressed after each presentation.
Great. Christy, good morning. And Lynn and Christy, thank you. And thank you to the Medical Society for hosting Jessica and I. We're a tag team combination, both working in the healthcare space, helping providers of all shapes and sizes with all different sorts of issues. So there's a bunch of slides we want to get through today. As Christy said, if you have questions, please put them in the chat box. We will do our best to be done by 5 o'clock or so tonight. Oh, no, maybe not quite that long. We'll make sure to be done by 10 to 9 and see if we can leave some time for questions. But in all honesty, there are more slides and more information that we can cover in the short amount of time we have today. If anybody has any questions or something we go through too quickly, please feel free to shoot Jessa or I an email, or Jess and I an email, and we will make sure to get back to you if we are able to answer your question. Can you jump to the next slide, Christy? So as I said, we're going to cover a lot of information today. And you can go back. There we go. There's a bunch of information we want to try and cover today. Again, in all honesty, we could spend 45 minutes on each of these subjects. We're going to give you enough to make you think about the issues, to make you spot the issues. I know we have a combination of medical practice professionals and physicians who signed up for the webinar. So we want to make sure it's applicable to all of your knowledge bases in terms of what we have. We both write regularly and speak. So to the extent there's articles that we write prospectively about any of these HIPAA issues, Christy and Lynn had shared everybody's contact information, so we'll be making sure to send you those articles in the future as we write them about topics that may be of interest. You can jump to the next slide, Christy. So we thought we'd start with some information about medical record release requirements, because we know that this comes up regularly in each of your practices in terms of patients asking for copies of things, and want to make sure everybody just has a fundamental understanding of the rules. One basic thing, and you can see we have a number of bullets on this slide, make sure you're only giving copies. Originals do not need to go to a patient or do not need to go to another practice. There are record retention obligations that we have. So certainly copies are permissible. You can charge reasonable expenses for sending copies over, even if they're electronic. There's a sliding scale in terms of how the state requires those charges to be made. You can charge for postage or shipping if they're shipped in that manner. Just note in that in the second bullet, the third sub bullet, there's a 45-day turnaround. So don't sit on those records. If a patient needs it, make sure to get it to them timely. Certainly, if it's medically necessary, need to get them to them sooner. And you'll see when we talk about some of the HIPAA stuff in a few minutes, there's timeliness requirements at the federal level with respect to HIPAA requirements. One interesting development in this third bullet, if for some reason the new physician and the patient agree, which I personally have not seen happen, but I guess it could, there's a possibility that the transferring practice could just send a summary of the information at no charge to the patient. But most practices that I'm aware of, they prefer to get copies of the entirety of the medical record so they can make sure they're giving proper medical advice to that patient. But there is this unique exception that you can simply provide a summary and do that at no charge. Obviously, there's a 7-year record retention that needs to be in place for the records you hold. I'm guessing that most of your policies and procedures already address this. If not, we should make sure that that gets added. And then if you don't provide access to patient records, of course, the state medical board can get involved and they can discipline people were that to occur. You can jump to the next slide. One of the other things that often comes up is if people want to close a medical practice, there are specific rules. If somebody wants to truly close down their practice, what they need to do. If somebody's going to be leaving the state, there are timeliness requirements, there are notice requirements that need to occur. Bottom line is we need to make sure the patient knows what's happening, the patient knows what's happening in a timely way, and the patient gets adequate notice in terms of how that needs to happen, in terms of what they're doing and where they need to go. So just a very brief primer on the practice requirements with respect to medical record access and things you need. These are governed in the statutes and regulations. We're happy to share copies of that if that would be appropriate. Why don't we shift over to HIPAA now, starting in the next slide. I'm sure everybody has some familiarity with HIPAA, no matter how long you've been working in a medical practice or the owner or a physician in a medical practice. But there are important reminders in terms of patient access, in terms of what we need to do. So again, we're going to go through this stuff pretty quickly, but if folks have questions about the HIPAA information, we're happy to share. You can jump to the next slide. So everybody knows what HIPAA is all about. It's about patient access to records and what we need to do, how we need to provide access, what that access entails, what patients can and cannot get, how information can be shared from one provider to another or between a provider and a payer, and what needs to happen in that regard. You can jump to the next slide, Christy. In terms of the basic overview, because of the lawyer in me, the statute was passed back in 1996. There were subsequent changes to the statutes in the early and mid 2000s. There are a series of different regulations that have been put together that basically what happens is when Congress puts together a statute, the president signs it into law, they then say, hey, regulatory agency, help us interpret what we meant and what does this really mean? So a series of different regulations came out, hundreds and hundreds of pages explaining what the intent was, what the purpose is, what the exceptions are, and we'll talk about some of those in a moment. So you can jump to the next slide, Christy. Couple of basic buckets that we're going to talk about today: the privacy rule, the security rule, what happens if there's a breach, and what's the enforcement priorities in terms of where things happen. When people often think about HIPAA, they just often think about HIPAA privacy. At the very beginning of this process, when the HIPAA statutes were enacted and the regulations came out, there was a tremendous focus on the privacy issue. over the past 5 or 6 or 7 years, as more and more things become electronic in their transmission and their storage and the retention, the real focus has shifted over to the security standards in terms of what people need to think about. You can jump to the next slide. In terms of what the privacy rule is all about, it focuses on protected health information, or PHI, and all of you are probably familiar with that acronym in terms of what that is. It applies PHI that applies to quote unquote covered entities. You can see both of those are underlined on the slide. You can jump to the next slide. I apologize. We're going to go through some of these slides in rapid order, but I know Christy and Lynn will make the presentation available to people so they have this information if they'd like. PHI, again, is the focus. There's a definition in the regulations for what's considered protected health information. It's a very, very broad definition. It's basically anything that you can use to identify an individual. And there's a series of almost 24 criterion that they've listed in the regulations that can define. The important piece at the end of this provision is that's maintained or in electronic or any other form or medium. So those of you who are still maybe paper-based practices, which I'm guessing there are still maybe a few of you, it covers you. Those of you who have shifted everything over to electronic and are largely paperless, this applies to you as well. So we start with PHI. You can jump to the next slide. Here's a series of some of the different examples about PHI. One of the important takeaways that I want everybody to remember for purposes of this presentation, if you're not sure if something's PHI or you're not sure what you need to do or how you need to do it, please, please, please make sure to ask your practice's privacy officer. If the practice doesn't have a privacy officer, suggest that they do put a privacy officer into place. And if the privacy officer is not sure, make sure to reach out to your attorney or contact an attorney to make sure you understand what's PHI. These are easy foot fouls, easy ways to get tripped up in terms of what you're doing or not doing, and we want to make sure the practice is doing the right thing. You can jump to the next slide. So there are three main types of covered entities. You can hit it again, Christy. There are three main things. You can hit it one more time. Healthcare providers is what most of us are going to be for purposes of this presentation. You can see I highlighted most medical practices. Anything that's transmitted in electronic form and it's with a covered transaction, so you're dealing with third-party payers, HIPAA is likely going to apply. If you are truly a concierge practice, cash only, not interacting with other third-party payers, you may not be considered a covered entity, but before you reach that conclusion, you need to understand what it's all about. You can jump to the next slide. There are certain rules with respect to the uses and disclosures of protected health information. You can always send it without getting the patient's permission for purposes of things that are called treatment, payment, and healthcare operations, or what people in the healthcare world often refer to as TPOs, treatment, payment, and healthcare operations. If it's not part of one of those defined terms, and there are regulations that specify that, you need to make sure you get a compliant authorization from the patient in terms of sharing that information. You can jump to the next slide. Importantly, there are individual rights under HIPAA. One of the things we wanted to share with some knowledge with you about today, individuals have the right to access their protected health information that's held by the practice. Individuals have a right to get an accounting of the number of disclosures that the practice has made with respect to their protected health information. There are certain rights where protected health information can be amended. There are certain opportunities where there can be restrictions on people's protected health information. There are means by which the practice can contact the patient by alternative means. And I'm sure all of your practices have the notice of privacy practices. These sort of make the fundamental underpinning as to the things we need to think about with respect to patient rights in that regard. You can jump to the next slide. From a compliance perspective, and there's a series of sub-bullets, so you can just roll through these sub-bullets, Christine. I want to make sure from everybody's perspective that each of these things are in place for your practices. If they're not there, make sure you get it. Christy, you can keep going. There's like 10 or 11 different things on this slide that pop up. It stops with documentation. Just note that each one of these elements is incredibly important to make sure that your practice has in place. Once you have it in place, don't leave it sit on the shelf. Make sure that you're thinking about it, updating it, making changes to the extent there's any changes in the HIPAA regulations and changes in the way your practice is doing things. So that's a very, very, very quick overview of the HIPAA privacy rule. Again, there's a lot more detail than that, but I want to switch over now to the security rule. You can switch to the next slide. So the security rule deals with electronic PHI. So again, privacy rule is all information. The security rule deals with the electronic information. There are a series of different requirements under the security rule that every practice needs to think about with respect to administrative, physical, and technical safeguards. You can jump to the next slide. And there are a series of sub-bullets under here too, Christy. Yeah, there's 3 sub-bullets. Perfect. So a couple of things I want everybody to think about. There are these administrative safeguards, there are physical safeguards, and there are technical safeguards. Every covered entity needs to do things. And to make things a little more complicated, when the government set these up, they set up 2 different sets of requirements. One is what's called the required specifications that every covered entity, regardless of size or shape or location, needs to abide by. And then there's what they call addressable implementation specifications, which a solo practice might have very different specifications in terms of what they can afford to do or need to do or are able to do than a place like Christiana, a very, very large health system. So just note, in each of these safeguards, there are things that everybody has to do. These are the required specifications. And then there are things that are the addressable specifications that really need to go through a thoughtful analysis in terms of understanding what's enough, what's the minimum you need to do, what do you need to do to make sure you're protected, and then how do you continually evolve through that process. You can jump to the next slide. In terms of a couple of big picture things to think about, be very, very careful about malicious software. Don't click on something if you're not sure what it is. There are these phishing, PHISHING, stories that happen every time and every day in medical practices. If you're not sure where it's coming from, pick up the phone and call and say, hey, Jess, did you send me this information? It came across in an email. It's an easy way for a hacker to get access to your system, which can be very destructive and damaging that we'll talk about. A couple of other things to think about. Don't put PHI on your personal devices. I know everybody has their cell phones and it's an easy way just to send information back and forth. If the appropriate security standards are not in place, don't do it on your personal devices. Be very careful about your mobile devices. If something gets stolen, making sure there's password protections or automatic lockouts in terms of when things happen, because these are the type of things that can lead to breaches. It's really trying to be smart. It's like almost like the old KISS principle that many of you are familiar with. Keep it simple, STUPID. We want to make it smart for yourselves, protect you in terms of what you need to do, and don't be an invitation to somebody who might have alternative means. You can jump to the next slide. There's a definition here for security incidents. You'll see this many times in your compliance programs that you need to place or in your business associate agreements that you as covered entities might have with other parties. Just know what's out there, know what needs to be triggered in terms of data disclosures, know how it can be worked. Healthcare entities are still a big, big target in terms of what happens. You can jump to the next slide. So what happens when you have a breach? These can happen to any practices. They happen in many practices of all shapes and sizes, as well as health plans and healthcare clearinghouses. There are federal obligations that you need to be aware of in terms of who you report the breach to and how does that work. So we jump to the next slide in terms of a definition for a breach. Again, it's a very complex definition. You can see in the top half in the bigger text what's considered to be a breach. There are certain exclusions that are built into that breach factor. If you think your practice could be subject to a breach, there's an analysis that you have to do. The presumption is that a breach occurred unless you can prove that it otherwise did not happen. You can jump to the next slide. You can see here's the analysis in terms of what needs to happen. If you look at that second bullet, again, because the presumption is there is a breach, because from the government's perspective, they wanted to make sure that individuals were protected from unpure uses or impure uses of their protected health information. So if you want to overcome the presumption there was a breach, you must be able to demonstrate and document there's a low probability that the protected health information has been compromised by doing a risk assessment. So if you run into one of these situations, talk to your privacy officer, talk to your security officer, talk to your counsel about these issues to make sure you understand what needs to get done. You can jump to the next slide. So heaven forbid there would be a breach. There are notification requirements depending upon the size of the breach in terms of where the notice needs to go, who's going to be implicated by that, what the timeline is in terms of where you need to get it. If it's a sufficiently large breach, you'll need to make sure the local media knows, which no covered entity wants to go through if they can avoid those circumstances. You jump to the next slide. Because it's a law, there are penalties. Just note, if the government gets involved, there are different penalties that can occur. Your liability insurance or your cyber insurance or your breach insurance may or may not cover some of these different incidents. Obviously, you need to make sure you have appropriate insurances in place. Talk to your insurance broker about that. But in addition to the things that can happen, there are some really jaw-dropping fines that can be out there. Now, oftentimes they can be subject to negotiations, but if you look at just that first one, $100 to $50,000 per violation, if there's 20 different identifiers that were released in one patient record, you potentially could have 20 different violations, not because it was patient Bruce Armon's record who was violated, but it could have had Bruce's name, date of birth, practice location, insurance status, a number of different things that it can get very, very expensive very, very quickly if these things happen. Jump to the next slide, Christy. You can see one more forward. There we go. As we talked about at the state law level as well, at the federal level, there is a federal right of access initiative where patients have the right to get their records within 30 days of making a request for that information, and other opportunities that the patient has as well. Just know the federal government has been cracking down on these. They want to make sure that patients can get access to what they need. You can jump to the next slide. I included on this slide several examples, and there's actually 2 slides of this, but you can just see just in this first slide, there is requests and penalties that were agreed to in this right. You can see these numbers add up pretty quickly in terms of what happens. You can jump to the next slide as well. Again, you can see here some other examples. These are real dollar amounts that really can affect the practice in terms of what's happening. So just if patient asks for a record, be mindful of it at the state level, be mindful of it at the federal level as well in terms of what it can mean. So what do you have to do? You can jump to the next slide. Make sure that you protect your protected health information. Make sure you follow the privacy and security policies that are in place. If they're not in place, please make sure to put them in place. Please make sure they're regularly monitored and updated. If you suspect there's a HIPAA issue, talk to the privacy officer, talk to your counsel. These things, you can't hide them under the rug and think it's going to go away. It's better to address it up front, figure out what the circumstances are, and then move forward accordingly. You can jump to the next slide. Breaches do happen. As of October of 24, over almost 375,000 complaints to the federal government about issues affecting the HIPAA privacy rule or the security rule. I included a link here so you can see the number of cases that are under investigation. It's a long list all across the country, all sizes and shapes of different things. You can jump to the next slide. One of the bad things, if you will, you can see on this slide, healthcare has had a significant increase since 2022 in the amount of cyber breaches and the cost of these breaches. One would normally think like industry or the energy sector or the pharma sector, but nope, it's healthcare that's number one in terms of the changes since 2022. And you can see on the second half of this slide, the expense of the cost of these in terms of what needs to happen in terms of how it's going to work. You can jump to the next slide. In terms of the number of healthcare breaches, you can see on that left-hand column, consistently healthcare breaches for healthcare providers is the highest level. Again, there's the three main columns or four big buckets: the healthcare providers, the healthcare plans, the Blue Cross Blue Shields of the world, the business associates, and then the healthcare clearinghouses. Disproportionately, healthcare providers have the most number of breaches every year. You can jump to the next slide. Some information about what the data shows: multiple data breaches. You can look at the very last bullet. The breaches have affected more than 2.5 times the population of the United States. 2.5 times. So it affects everybody, or it's affected multiple people from multiple practices in terms of how it works. These are really, I can't overstate how significant these statistics are, and the potential harm and risk to the practices and covered entities in terms of what they need to do. You can jump to the next slide. If people are not comfortable seeing things in words, you can see it in a graphic format. Healthcare breaches affecting 500 more individuals. You can see the significant spike from 2017, 2018, how they've jumped up disproportionately. Obviously, the number for 2026 is still relatively light, but we're only a third of the way into the year in terms of where that stands. Next, you can jump to the next slide. What are the causes of the breaches? You can see at one point the hacking incidents, that blue line, has significantly jumped up, and the improper disposal, the loss, or the theft or unauthorized access have stayed pretty flat. But as hackers get smarter, they figure out more ways, and it's like that old Willie Sutton line, why do you rob a bank? You follow where the money is. That's where the hackers are going to. They're finding where the data is, finding where the weak spots are, and then trying to take advantage of that data that they need. You can jump to the next slide. As point of comparison, you can see the number of loss and theft incidents have dropped significantly over the years. It's still not something we should ignore, but most practices have gotten smarter about making sure that laptops are secured, for instance, so those things don't happen. So those are the issues that we need to address. The last piece before I turn it over to Jess, I know I covered a lot in a very short amount of time. You can jump to the next slide. I want to make sure that everybody understands, even though HIPAA has been around for 15 years, it's not something we can take for granted. It's not something we can forget about. Every day, every patient interaction, every engagement that you're having touches on patients' protected health information, and we need to make sure that that information is addressed. So maybe I will pause there because I want to make sure Jess has more than adequate time to talk about some of the litigation issues. Christy, Lynn, I'll leave it up to you if people want to ask questions now, or we want to wait till the end after Jess's presentation.
Thank you so much, Bruce. That was a great presentation. A lot of information that is very useful packed in there. We do have a couple of questions. You had touched on this earlier, but someone asked, when patients request records, can they charge to send it to the patient? Would you mind just touching on that again real quick for us?
Sure, absolutely. And I appreciate the question, and apologies if I ran through things too quickly. As I said, there's a lot of information we want to cover in a short amount of time. So yes, in Delaware, there can be charges for patients getting the copies of their records. It's actually delineated in the regulations. It's $2 per page for pages 1 through 10. It's $1 per page for pages 11 to 20. It's 90 cents per page for pages 21 to 60, and then 50 cents per page for pages 61 and above. Now, we can certainly email this information to you. You don't have to charge those fees, but the fees can exceed that amount in terms of what they need to do. So yes, you can be charged. It's driven by state law in terms of what those charges are.
Thank you, Bruce. Our second question was, in the case of a custody issue due to legal action, such as divorce, is it okay to place a request on hold until legal clarification is obtained from the court? I'm assuming they're referencing medical records.
Yes, another good question. One of the important things that most practices have when they do their intake forms, particularly when you're dealing with minors, is who has access to the forms, whether it's mom, dad, custodian, whoever it is. So getting those forms at the intake process can always make sure. I've seen, unfortunately, issues that have occurred where dad or mom asked for records of a child and the other parent did not permit that to occur because they're in the midst of a nasty custody dispute. So before any of that information shared, make sure in your intake forms or you get written affirmation from both mom and dad or guardian or grandparent, whoever it might be, who exactly has access to rights for that minor child.
Great, thank you. Great information. And then I have one last quick question. How important is it for practices to perform a risk assessment?
It is very important. I would encourage clients to do that at least once a year in terms of doing a risk assessment so you understand where your data is coming from, where your data is going to, and you understand all the steps in that process, whether things are through an outside billing company, whether things are through a business associate, another vendor who the practice is using. Make sure you have a clear sense as where your data is coming or going, because heaven forbid, if your practice ever suffers from a breach and the Office for Civil Rights at the federal HHS level ever comes and does an investigation, the first thing they're going to look at is say, what do your policies and procedures say? When did you last do a risk assessment? Have you factored or mitigated these certain circumstances? You're immediately going to be on the defensive if you're not addressing those things up front. So it's always better to be proactive than reactive in these situations.
Great information. Thank you, Bruce. I'll let you turn it over to Jessica. I'll just note that we will allow time at the end of Jessica's presentation for Q&A as well. So if you have questions, keep putting them in the chat box. Thank you.
Great. Jessica, the floor is yours.
Thank you, Bruce, and good morning, everyone. It's very nice to be here speaking with you all today, and I really thank you for your time. I know how busy you all are. So the next topic we want to discuss is powers of attorney. Depending on your role, you may deal with these with some frequency, but if not, I just want to back up and we can move to the next slide. And explain exactly what a power of attorney is. So a POA is a legal document that designates a person to make medical decisions on behalf of another, and that's generally, but not always, if that person is incapacitated. We can move to the next slide. So a person that holds a valid POA, and we'll get to what valid means in a second, essentially stands in the shoes of the patient with respect to HIPAA and other related privacy laws. That means they will generally have the right to access and receive confidential medical records to the same degree as the patient would. If the patient could not get information under HIPAA, the same would be true of the agent holding the POA. So one example of a situation where a person with a valid POA might not be entitled to records would be like notes from counseling sessions that are kept separate from a patient's chart. But generally, and again, unless there are some exceptions, they're going to be able to get everything the patient could. We can move to the next slide. So in Delaware, a practice is required to comply with the request for medical records if the agent seeking the records holds a valid and active POA, and generally the patient is incapacitated. We can move to the next slide. So what should you do if your practice receives a request for information that is supposedly supported by a POA? So you want to start, and I would always encourage you to seek advice of counsel to the extent you have any questions about the validity of a POA that you're presented with. But the first step is you want to ask for the original of the document rather than a copy. You then want to verify the POA. So what I mean by verification is you need to ensure that it was signed either in the presence of a notary, so the document is notarized, or it was signed in the presence of a witness, or it complies with the requirements of the state in which it was issued. And that is going to, take a little more legwork. And I do definitely encourage you to seek the advice of counsel to the extent you have questions, because I can generally only speak to what Delaware requires. Other states may have different requirements. Um, you also want to verify the agent, meaning the person holding the POA's identity. And to do that, you just want to confirm that the person is named as the agent in the document and they are who they claim to be by asking for their identification. You also want to check the scope of the POA. Most POAs you're going to be dealing with are called springing, and that means they are triggered by the patient's incapacity. If the POA is springing, the agent would only be entitled to information, the patient's information, if they are in fact incapacitated. So you will need to verify that. There are two ways you can verify that. One is from a written statement by the patient's physician saying that they are incapacitated, and the other way would be through a valid court order, essentially saying that the patient cannot act on their own behalf. There's one exception to the ability of an agent to get information on behalf of a patient, and that would come into play where a practitioner believes that the agent is somehow abusing or neglecting or endangering the patient. If that is the case, the practice may be able to refuse the request for information. We can move to the next slide. Oh, one second. Just one more note on POAs. Once you confirm a POA is valid, you should make sure to scan a copy of the original into the patient's health records. You should make a note of the date that the original POA was reviewed, the fact that the original was actually reviewed, and then the name of the staff member who verified the validity of it. And to the extent you need to update the patient's emergency contact information to reflect what's contained in the POA, particularly if you need to include the agent as an emergency contact, I would encourage you to do that at that time. Okay, so now we will move on to subpoenas. This is something else your practice might receive with some frequency. Kind of depending on your role, you may be very familiar with subpoenas. We can move on to the next slide. So a subpoena is a formal legal document that compels testimony or the production of information. You will most frequently deal with subpoenas that are requesting medical records. Those are called subpoenas ducis tecum. So they want things rather than, having a person come and testify either live at a deposition or in some type of court proceeding or trial. If you receive a subpoena, I really encourage you to consult with counsel. Counsel can help you verify the validity of the subpoena and flag any issues. And the biggest one would be dealing with the scope of a subpoena. I deal with them all the time. They are very, very broad. They typically ask for everything under the sun, but that does not mean that the person seeking the information is entitled to everything under the sun. And typically, there will be some form of objection to the scope and breadth of a subpoena. We can move to the next slide. So when you receive a subpoena, you want to make sure that you take action when you get it. You don't want to ignore a subpoena because this is a legal request that could carry penalties for failing to comply. They almost always require a prompt and very formal response, and there's usually a deadline for compliance set forth in the subpoena. You also want to make sure to immediately preserve any records that are sought by the subpoena, and that's true even if you intend to lodge objections or think the subpoena is somehow improper. We can move to the next slide. So under HIPAA and other relevant privacy laws, a subpoena by itself is not enough to compel the release of protected health information. In most cases, you're going to need satisfactory assurance that a patient was notified or consented, or you're going to have a valid court order. Now, a court order is a document that's signed by a judge, and it's compelling the release of the records that are sought in the subpoena. If you receive a court order, you are generally going to have to release medical records, even if you don't have patient authorization. But again, you're only required to produce the records that are specifically sought in the subpoena. It doesn't mean that you would give over a patient's entire medical history. If you don't have a court order, you want to make sure that you have a valid authorization from a patient or you obtain patient permission. If you can't get that, there is, a notice and objection period that would have to go by before you would give over the documents. So I would really encourage you to make sure that your compliance team or whoever you have handling document and any kind of information request is properly trained with respect to subpoena intake. And again, you want to make sure that you're only giving the information sought by the subpoena. Not everything related to a patient is necessarily going to be subject to production. We can move to the next slide. Um, so just kind of walk through the steps you should take when you get a subpoena. So first step, we would really encourage you to contact counsel. Again, these things are typically very broad, and I would say frequently too broad. So there can be proper objections that you can make and get the scope of the subpoena limited. They can also help determine, particularly if we're dealing with an out-of-state subpoena, whether the subpoena is proper and it complies with all the laws it needs to comply with so that you are okay in giving protected health information over in response to the subpoena. You need to make sure to check the validity of the subpoena. You need to make sure that the party issuing the subpoena has the authority. Again, that's either from a court or from a patient themselves. And again, if you have neither, there's a requirement that the patient gets notification and then a certain amount of time has to lapse for the patient to object before you can give over the records. You need to make sure a subpoena has all supporting details. You need to make sure that it's clearly describing the information that it seeks. You should note whether or not this is a deposition subpoena or a testimonial subpoena, or if it is just requesting documents, and what is the date required for the response. Again, these carry the force of law, so if they're setting forth a date, you want to make sure that you are doing what you need to do to get either the information or an objection lodged by that date. Or if the subpoena requires testimony, you need to know kind of what the information that you need to comply. Where are you being asked to appear? What is the date? What are the bounds? Can I lodge any objections to actually having to go and testify? And then you need to determine whether or not there are jurisdictional issues at play. So does this subpoena relate to an action that's pending in a state other than Delaware? And if so, there may be additional hoops you have to jump through to comply. You should also make sure to be documenting all of the steps you're taking from receipt of the subpoena until the time that records, if any, are ultimately disclosed. So that would be the date you received it, the scope of the request, what the subpoena is asking you to produce, whether or not that request is overly broad or otherwise objectionable, and if so, the date you lodged objections, and then the date records were provided and what was actually provided. We can move to the next slide. So the last thing I want to talk about, and this is an issue, we've received kind of a lot of requests about, and that is your practice's obligation with respect to information and kind of how that coincides with ICE and immigration issues. So we can move to the next slide. So immigration status is considered protected health information. So medical staff generally cannot disclose patient information ICE, including their immigration status, without some form of subpoena or other court order. Medical practices have no affirmative legal obligation to inquire into or report to any immigration authority a patient's immigration status. And an ICE agent cannot enter non-public private areas of your practice. So that would be like an exam room or a back office or anything designated by your practice as non-public without some form of a warrant. And a warrant here is something that is signed by a judge or a magistrate. It is not something called an administrative warrant signed by an ICE agent. That would not get an agent access to non-public areas of your practice. Again, it has to be signed by a judge or magistrate. An agent could, however, enter public spaces of your practice. And that may be, again, depending on how you've designated areas in your practice, a waiting room, common areas, parking lots, sidewalks outside your practice. And they can also ask questions of staff and providers that are present in those common areas. But in the absence of a judicial warrant, you don't have an obligation to actually respond. Um, ICE does have the authority through the Attorney General's office to actually issue a subpoena that would require production of certain information or testimony. But again, that has to be a subpoena or the warrant signed by a judge, like I mentioned. It would not be something called an administrative warrant, which it's called a Form I-200 or I-205, and that's a document that is signed by an ICE agent, not by a judge or a magistrate. So if you receive an administrative warrant, you should take note because that would not grant the agent access to non-public information. We can move to the next slide. Next slide. So what should you do? So before you encounter these issues, I would recommend that you take some proactive steps, and these are things you can be doing now. You should designate someone who is knowledgeable about patient privacy and rights and how best to respond and interact with ICE agents ahead of time. That would be someone who would know how to check for a valid warrant that it's again signed by a judge and not by an agent or review a subpoena, but then generally just be informed as to best practices and what is and is not appropriate in dealing with ICE agents. And that would kind of be the person who is front and center so that there's kind of no confusion and you're not dealing with a situation where an agent is kind of questioning everyone, trying to get to the person who has information. You want to designate ahead of time what areas of your practice are considered private and which are public. I mentioned a waiting room is typically something I view as public. That doesn't have to be the case. That could be something that, there's a barrier to entry and your practice is designating as a private area. You should generally avoid, to the extent possible, collecting immigration status information from your patients. If you must, perhaps to verify Medicaid eligibility, you should generally avoid including that in a patient's medical records. You could also provide posters and educational materials to patients that would advise them generally of their rights in dealing with an ICE agent, such as the right to refuse to answer questions and the right to seek a lawyer if they would like to have one available to assist them. You should ensure patient records and screens are not visible in the public areas of your practice. There's something called a plain view doctrine, or kind of it would allow an ICE agent to kind of take anything that is visible or information that they could overhear. So it's really anything available to the ICE agent's senses could be kind of subsumed within that plain view doctrine and could allow them to take things from public areas that they otherwise wouldn't be able to access. You should also make sure not to talk about patients in public areas. We can move to the next slide. So if ICE does enter your practice, I would really encourage you to contact counsel for advice. Again, you don't want to provide any medical information in the absence of a judicial warrant signed by a judge or a subpoena. If you are given a warrant, you want to confirm that it is valid and signed by a judge. It states the specific address of the premises to be searched and make sure that actually matches your practice's address. You want to make sure that if there is a time period set forth in the warrant, that it is being executed during that time frame and is not exceeding the scope of the warrant. And you want to make sure to note what the scope of the warrant is in terms of the type of information that can be collected and searched. If it specifies a specific area, they can't exceed that area. They can't go beyond it. They can't search rooms that are not contained in the warrant, and they can't ask for information or records that are not reflected on the warrant. And that's where, it would be key to train an individual to review these documents to make sure that all of these things are true. And that's everything I have.
Thank you so much, Jessica. What a great presentation. I do have, please put your questions in the chat or raise your hand. We're happy to address your questions. I do have a question. If the OCR were walked into a practice with for an audit, does the practice have to address that immediately, get those records, get everything done right then and there because they want it now?
Do you mean ICE?
No, the OCR. I'm sorry.
Oh, I'm sorry, Lynn, could you say the question one more time? I apologize.
Sure. I'm sorry. If the Office of Civil Rights were to um, walk into a practice and demand an audit at that time, does the practice have to drop everything and do it then and there, or do they have options?
I've never seen OCR come in, and I'm not aware of OCR ever coming in right away and doing an audit. What would typically happen is somebody would file a complaint. As a result of the complaint, OCR would investigate, and then OCR would send some sort of a demand letter to the practice asking for a bunch of pieces of information, then potentially scheduling an in-person interview. So unlike some of the things Jess was talking about with an ICE agent and warrants and whatnot, OCR doesn't act in that manner that I've ever seen. It's more of a deliberative process, getting information, trying to get answers to questions, and then following up accordingly.
Great. Thank you,
Yeah,
Bruce.
and Lynn, on that point, like I would pay attention to any notice of audit you receive because that's typically going to contain kind of the timeframes for compliance and when things are going to start moving forward.
Great. Thank you, Jessica. Great information. How does a
I'm
practice know, Jessica, if they receive a subpoena? I do receive a lot of questions about subpoenas. A practice will call my office and say, "I received a subpoena in the mail. What do I do?" Do you receive subpoenas in the mail?
Yes, that is typically the method for receipt of a subpoena. I mean, when our office sends subpoenas to medical practices, we are typically putting them in the mail, and that's because that is a required means of notification. It may not be the only means, depending on the relationship between kind of counsel serving the subpoena and the practice. I may kind of follow up with an email or send something through a different format, but you typically have to comply with the mailing requirement. So while you might get it another way, you are typically going to receive it in the mail.
Thank you.
Lynn,
And
if you want, you can jump to the next slide, because we included a couple of links that from some of the recent HIPAA and fraud and abuse things that we've written. So, I mean, if you send this around to people, people can click on that hyperlink, or they can go to the firm's webpage and see some of those alerts if that's helpful, just because of the limited time we had today to get a sense for some of these different issues that are out there.
great. Thank you. Great links. Oh, definitely. Thank you so much. Do we have any other questions for Bruce or Jessica this afternoon, this morning?
I have a quick question. I was just thinking back to the power of attorney slide. So, we recently had a case, which is really rare, where two parents give guardianship to a grandparent. So our understanding is this doesn't necessarily mean that parental rights are revoked in any way, and parents can fully access medical records without consent of grandparent who's the current guardian, correct?
That's typically the case, but you're gonna want to pay attention to anything set forth in the document that the grandparents are providing to request information to make sure there's nothing, there that would cut off the rights of the parent, or kind of otherwise speak to what the grandparents are entitled to request on behalf of the child. If
Oh,
someone is a guardian, most of the laws we're going to be dealing with kind of would include them as well, but it wouldn't remove the rights of the parent unless there's something kind of speaking to parental rights.
okay, definitely on board with that. Thank you.
Great question. Any other questions for Bruce or Jessica? I do have a question in the chat box. What is the extent that a practice can pursue the legal status of a patient?
Jess, do you want to take that first? Do you want me to take that?
Yeah, no, I'm happy to. And you mean legal status in the sense of kind of immigration status? Is Do I understand that correctly? I see no.
So,
I
so,
don't
so
know that I
maybe,
actually understand the question. Bruce, do you? I was
no, I was
assuming
going to say,
immigration.
I mean, so if it's a question of if the individual is eligible for insurance, you can certainly at the intake process, depending on what type of practice, if it's a emergency medicine situation in a hospital because of EMTALA, there's an obligation to treat everybody as they present, and you deal with things after the fact. But in terms of a traditional outpatient practice, if somebody's coming in and they're not participating, I'm not sure this is directly on point to your question, but if they're not participating with one of the third-party payers with which your practice participates, you don't have an obligation to see that patient.
Oh, got it. So whether or not like a patient is incapacitated, I think is the question here. So you would want proof of incapacity to the extent that there is a question about whether or not like the patient would be entitled to their own records, like if they could seek information on their own behalf. I think the presumption would be in favor of capacity unless, you as a medical professional have concerns regarding that. With respect to the POA, I mean, you're generally being presented with documentation saying that the patient is not does not have capacity, and that's when you want proof from either a court or a treating physician to the extent that you are not the patient's treating physician, kind of setting forth that incapacity. But I think that if you're dealing with the patient themselves, unless there are concerns regarding capacity, the presumption would be in favor of capacity.
Jess, it looks like there was a
Yeah,
follow-up question.
I would expect that you would be presented with a court order. You wouldn't have to do the legwork. You're going to be, someone is going to be making a kind of request on behalf of another to your office and presenting a power of attorney. They should be supporting that with a court order. And if not, you would go back to them and ask for the support of a court order if you don't have an authorization signed by a patient. But you shouldn't have in this situation where you're dealing with a document request, it wouldn't be on you to affirmatively contact a court.
Yeah, and then Lynn, I appreciate you putting that last slide up. Obviously, just as attorneys, we have to make sure this is just general information that we're providing and not creating any attorney-client relationship. So thank you. But obviously, if folks have questions that come up after this, Jess and my emails are at the bottom of the slides that I know Lynn and Christy are going to send around. So if there are follow-up questions or we can provide some additional assistance, just let us know.
Great, thank you both. Yes, and this is being recorded, and Christy will be sending a copy of this out to all of the attendees this afternoon. Christy, I'll turn it back over to you to close us out.
Thank you. I was just trying to close out them slides there. Thank you again. This was a definitely very informative and a great presentation from the both of you. As again mentioned, we did share Bruce and Jessica's contact information on the slides. If you missed it, I will be sharing a copy of today's presentation. The session was also recorded, and we will be uploading it to our YouTube channel. So if you're not following us, please feel free to put a follow, as we regularly do upload educational content on our YouTube channel and our social media platforms, Instagram and Facebook. So again, thank you again for your great presentation. I'll go ahead and share all this information later on today. Thank you everybody for joining.
Thank you all.
Thank you.
Thank you so much.